I continue to be plagued by some tech problems that sort of make my life difficult when I'm on Zoom. I hope we don't get too much of that this morning. I have IT hopefully watching, courts IT watching, and being able to correct anything. The big issue right now is it sounds like my sound, I'm understanding my sound is a little occluded, but I'm sort of yelling at the screen. And so hopefully we can get through what looks to be pretty simple matters this morning without too much more delay. And at least the IT department can be watching this and maybe come up with a solution for my later hearings by Zoom later today. So I have 4 cases this morning. There's a lot of you here, but they're all relatively straightforward, I think. But let me see who is all here on particular cases. The first one I have is Gutierrez versus Train. And that looks to be a settlement prove up. Is that right?
That's right, Your Honor. Luke Dow, guardian ad litem. I know
Dallas.
we all emailed this morning. This will take 10 minutes or less.
Thank
Colin
you.
Moore for the plaintiff as well, Your Honor, and Ms. Gutierrez is here as well.
Your Honor, apologies for the background noise. It appears that my neighbors are getting their lawn mowed, but Odalis Kovarubi is here for defendant Train Technologies Company and Craig Cody Warnicki.
Thank you. We have an interpreter here on this one. Is that right?
Yes, Your Honor. Good morning. That is correct. My name is Eric Franco, Master License Court Interpreter 2519.
I do not believe I have the double channels set up, and my JEA is off today, so we're just gonna do it old school. Well, where you will, once we go on the record, we're not on the record yet, where you will interpret as we go. We'll just all wait and have you interpret. It takes a little bit longer, but I think at this point, giving the tech challenges I'm already having this morning, I don't also want to set up the interpretation channel because I don't know how long that's going to take. And so if our hearing takes 15 minutes as opposed to 10, let's just do it old school, if that works for everybody.
That works just fine.
Yes, Your Honor. It's okay.
All right, thank you. We'll come back to that one. We'll probably start with you guys. Ms. Racanelli is set up for your record. But let me see who else is here on the other matters. McCrary versus Alcedo.
Leslie Warren, Your Honor. I'm here for the plaintiff. I am not the movement, though.
Thank
Yeah,
you.
Jay McGregor here for the defendant, Your Honor.
And it's a continuance hearing, is that right?
That's correct, of a trial setting. Just trying to get it continued until September, so a short continuance. My client's out of the country.
And do you need a record?
Yes.
Yes.
All right, well, you'll go second probably. I mean, if somebody else doesn't need a record and it's simpler, they may jump ahead of y'all, but you'll be after the one that's ahead of you. Thank you.
Okay.
And then Flores versus Santa Cruz.
Yes, Your Honor. Ruben Rios here on behalf of the defendant, Santa Cruz Landscaping.
Ben Kittlegrad here on behalf of plaintiff Ms. Flores.
You're muted. Sorry.
Yeah, I tried to click it. I'm sorry. Danny Andrews, I'm the ad litem, and thank you very much, Your Honor.
And then you all are saying you do not need a record, but it's also a minor settlement prove up.
Minor settlement prove up, and I'm not sure if Ruben, do you need a record?
I think I do. I think whenever we do these minor prove ups, we like to get a record just so that we have all that.
All right, and then if there's anything confidential that I need to look at that you don't have loaded up in the file, I need you to send that to me. I'm not saying you have or you haven't. I have a lot of short matters this morning, and there's a lot of cases that are similar. So just if your paralegal needs to send me something, send it to that 201.submission@traviscountytx.gov email, 201.submission@traviscountytx.gov. It's the one on the website. That goes for anyone. If there's final judgments you want to send me, send them to me there. Agree as to form. That's kind of the place to send me your paperwork. 201.submission@traviscountytx.gov. All right, thank you. So we'll take a record there as well. And then the last case is probably Smith versus Pitts Construction.
Yes, Your Honor. Thank you. I believe we're all here. It's another minor prove up. We've got 2 minors, so probably take less than 10 minutes on that one as well.
All right. And then also y'all want a record.
Yes, Your Honor.
And the guardians ad litem are here for everyone, and there's a parent here to testify for all of those cases as well.
Yes, Your Honor, I'm the ad litem on that one. I see Miss Topsy. I don't see Miss Smith, but perhaps she's under a name I don't recognize.
Here.
Okay,
Oh,
great.
she's the iPhone. Okay. And then we lost our Spanish interpreter. His audio cut out. So we're waiting on him to come back. Let me see while we're waiting if maybe somebody can come in and fix my sound real fast and we can go from there. Thank you. I'm going to go off for a minute and I'm not going to disconnect, but you won't see me on screen. Thank you. Well, we still can't figure it out, but we're just going to go from here and I'll just talk loudly. I think it'll be fine because everything until the motion for continuance at least feels agreed to. So we might do the motion for continuance last. Just so you know, because I'm going to try and get my sound woes worked out by then. All right.
I can hear you fine.
Yes, I am yelling though. So, anyway, okay. Let's go ahead and do the first case again. If everybody's back, I see the interpreter here. So, and we're going to have to delay for the interpreter, remember. So it'll be a longer record. 3. Okay. Nancy Gutierrez versus Train Technologies.
Your Honor, Luke Dow, guardian ad litem.
Abrimos sesión
Hold on,
GN
we need to interpret it, right?
21-4433, Nancy
Oh.
Gutierrez versus Train Technologies.
Let me take attorney announcements for the record.
Colin Moore for the plaintiffs.
Odalis Covarrubias here for defendants.
Luke Dow, guardian ad litem.
You may call your first witness.
Your Honor, if we could call Nancy Gutierrez and get her sworn in.
Yes.
Mr. Dow, you may ask your questions. Leave
Thank
room
you.
space for the interpreter.
Nancy Gutierrez, Santiago.
Nancy Gutierrez, Santiago.
You are the mother of Yannick and Mark, is correct?
Ustedes.
Sí.
Yes.
You and your children were involved in a car crash on April the 2nd, 2021, yes?
Sí.
Yes.
Y'all were westbound on Howard Lane and the defendant pulled out in front of you from a private drive.
Sí.
Yes.
And that's how the collision occurred.
Sí.
Yes.
Yannick was taken by EMS to St. David's.
Sí.
Yes.
He had a fracture of his left tibia, which is the lower leg, correct?
Sí.
Yes.
There was no surgery performed, but he was put into a long leg cast for a little over 4 weeks.
Sí.
Yes.
He then graduated to a walking boot and is now walking on his own, correct?
Sí.
Yes.
Mark was taken by EMS to St. David's as well, correct?
Sí.
Yes.
He had neck and back pain, was evaluated and discharged same day.
Sí.
Yes.
Mark did follow up with a chiropractor to address that neck and back pain, correct?
Sí.
Yes.
And he's doing okay now.
¿Y ahora él está bien?
Sí.
Yes.
You agreed to settle Yannick's case for the total amount of $30,000, yes?
Sí.
Yes.
And after the deduction of attorney's fees, Yannick will net $20,100, correct?
Sí.
Yes.
And Yannick's net recovery will be used to purchase a structured settlement through Pacific Life.
Sí.
Yes.
That structure will pay Yannick out when he turns 18, 2 times per year for 2 years, correct?
Sí.
Yes.
And the 4 payments are for $7,258.94 each, correct?
Sí.
Yes.
Mark's case settled for $20,000, correct?
Sí.
Yes.
And after attorney's fees are deducted, he will net $13,400, correct?
Sí.
Yes.
Those funds will also be used to purchase a structured settlement through Pacific Life.
Sí.
Yes. Yes.
And like Yannick, his structure will pay out beginning at age 18 twice per year for 2 years.
Sí.
Yes.
And the amount of the 4 payments is $3,826.38.
Sí.
Yes.
You have had a chance to visit with your lawyer as well as me, correct?
Sí.
Yes.
And you understand that you do not have to settle your children's case, correct?
Sí.
Yes.
If you chose, you could go try this case to a jury, and a jury might give one or both of your sons more than you've settled for. That's a possibility. A jury could also award one or both of your children less than you've settled for, correct?
Sí.
Yes.
You understand that by settling their case, you are waiving that right to go to trial.
Sí.
Yes.
And if the court approves this settlement, neither you nor your children can come back against these named defendants or their insurance carrier.
Sí.
Yes.
You believe that the settlement we've talked about this morning is in your children's best interest.
Sí.
Yes.
And you're asking the court to approve it.
Sí.
Yes.
Thank you, ma'am. I'll pass the witness, Your Honor.
Judge, you're muted.
Either the plaintiff's attorney or the defense attorney have any questions?
No questions for me, Your Honor.
No questions for me, Your Honor.
Then I have a few questions for Mr. Dow.
Señora.
Mr. Dow, tell me about this settlement and if it's a fair and reasonable settlement for the minors.
Your Honor, in my opinion, it is. Yannick had a broken leg. It was a non-displaced fracture, not requiring surgery, and he had no follow-up care after the hospital visit. The attorney's fees are a third, which I think is appropriate. And the structure is through Pacific Life, which, as you know, is one of the top 5 that we use in these situations. Mark did have a little bit of follow-up care after the emergent care that he received, but he was discharged and is doing fine now, as is Yannick. That was also a 1/3 fee, or actually 33% fee. Technically, it's not 33 1/3, it's 33%. And also a Pacific Life structure for Mark. If they were to reject these offers and go to trial, the expenses, which are currently at 0, are going to go way up. And the 33% fee will jump up to 40%. So looking at it from that perspective, and also what I think a jury would do, I think trial against this settlement would be too big of a risk. So I would ask the court to approve the settlement.
And then your fee for guardian ad litem work is in the order. It looks like.
It is, Your Honor, and that's over and above the settlements. It's not coming out of the kids' portions.
It's going to be paid by the defense.
Correct.
Do either of the other counsel wish to say anything further?
Nothing further from me, Your Honor.
Nothing further from me either, Your Honor.
I am looking at a final judgment that was submitted to the court that has everybody's signatures on it, and this is the one that I am being asked to sign. Is that correct?
Yes.
Estoy viendo.
Having heard the testimony and reviewed the file in this matter, the court is going to approve this settlement agreement and sign off on the final judgment as presented to the court. Good luck to you, Ms. Gutierrez, and to your family. And we can go. So let me take up the next one, which is the Flores versus Santa Cruz landscaping.
And Ms. Flores, if you're on, could you please just announce yourself? I don't see your name popping up anywhere.
We have an iPhone. I'm going to ask it to unmute. Let's see.
Yes, ma'am.
Is that you?
No, this is Miss Smith, Sharmika Smith.
Okay.
Then we don't have the guardian here. I'm trying to get a hold of her, but it's going straight to voicemail,
So
unfortunately.
you're missing the guardian ad litem.
No, the guardian, the mom.
Oh, the parent. Yeah.
Yeah.
Okay. So then, yes, we can't go forward. I'm going to, if you find them, I don't think they've been here this whole time though, right? I
No.
don't think they've been here this whole time. So obviously we have to have that.
Yeah.
So
Oh, yeah.
I'll wait, if you find her and y'all all go dark and however long it takes me to get through the rest of it. So if you got about probably 20 minutes to find her, so see if you can. All right, thanks. So that means I'll do Smith versus Pitts next. Now I think that means the iPhone. Let's see. We'll go back to you. Can we see you on video? Is that possible, Miss Smith?
Yeah, I'm trying to, I hit the wrong thing and I'm trying to figure it out right now. Hold on, let me get this going.
There we go. All right. Miss Racanelli, how are you doing? Are you about ready on this one?
I'm all ready, Judge. Thank you.
Thank you. Okay. Then we will go on the record. This Smith and Topsy versus Pitts Construction and William Pitts. Let me take attorney announcements and who you represent for the record.
Your Honor, I represent the plaintiffs, Ms. Smith and Ms. Topsy.
And what is your name?
Now Shanayak.
Thank you.
Megan Crow, Your Honor, on behalf of the defendants, William Pitts and Pitts Construction, Inc.
Walter Dean, guardian ad litem for two minor plaintiffs.
And have you all sent me a version of the final judgment that you want the court to sign off on?
Yes, Your Honor, we did that on Friday in response to the court's email, to the 201 submission email.
Thank you.
Yes.
Well, I will look for that. Mr. Dean, are you going to be calling the witness or is one of the other attorneys going to be calling the witness?
Yes, Your Honor, we're going to have two witnesses. So I believe I'll call Miss
Who's
Miss
your
Smith.
other witness? I'm sorry.
Okay, so there's two guardians because there's two minor plaintiffs. Sharmika Smith, who just turned her camera on, she's the guardian of Shakira, or the parent and guardian, and then Miss Tina Topsy is the guardian for Janelle. I believe she's on there. She's Tina down there. So
Right.
thought
I'm
I'd
gonna
call
have her
Miss.
to the same thing, showing both of her. And yes, there we go. So you'll call Miss Smith first, though.
Yes, Your Honor.
Miss Smith, could you please raise your right hand and be sworn in? In the testimony you're about to give, do you solemnly swear or affirm you'll tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You can lower your hand. Mr. Dean, you can proceed.
Yes, Miss Smith, you are the parent of Shakira.
Yes.
Okay, and she was in an auto accident that occurred on August 28, 23. Is that right?
Yes.
Okay, and following the accident, she presented to the ER at Dell Children's and was treated there. Is that right?
Yes.
And then there was some follow-up with chiropractic care.
Yes.
And just generally, the nature of her injuries were soft tissue strain and those types of things. Is that right?
Yes.
Okay. So the total settlement here for your child would be $11,500, of which there's $34,0168 in medical expenses, and 33 1/3% of it is also going to the attorney for a net of $3,751.30. Does that sound right?
I think so, yeah.
Okay. It's on the order of that, right? Even if you may not know it down to the penny, but that's generally what it is, right?
Yes.
Okay. And that's to be deposited in the court's registry until your child turns 18. Is that right?
Yes.
Okay. And we've gone back and forth with this case, but you and I have talked before, and you've talked with your attorney, your child's attorney, correct?
Yes.
And you talked about your various options before we got to the point of settling.
Yes.
Okay. And of course, you know that you could file suit and go to trial, right?
Yes.
And at that trial, you could get more or less. It would be up to the judge or the jury, whoever is the fact finder.
Yes.
Okay. So we talked about this, and you do understand that once you settle something, you can't go back and revisit the matter with the court, right?
Yes.
So if an injury were to come back or some new injury were to present itself in the future, you would be limited to the funds that you're settling for.
Yes.
Okay. Has your child recovered?
Yes.
Okay. And as far as you know, you don't expect any future problems?
No.
Okay. Okay. Are you asking, do you think that this settlement is in the best interest of your child?
Yes.
Okay. And are you asking the court to approve it?
Yes.
Okay. I will pass the witness.
Any questions for this witness, Ms. Snake or Ms. Crow?
No, Your Honor.
Your Honor.
All right, thank you. I don't have any questions either, so we may call your next witness, Mr. Dean. But don't leave yet, in case we have other questions, Ms. Smith. Thank you.
Yes, sir.
That would,
Proceed, Mr. Dean. You can lower your hand.
oh, I'm sorry. I'm sorry. I called you. You're the guardian. I confused your names. I'm trying to work with two different people. I'm got a little matrix here. Okay, Miss Topsy, you're the guardian of Janai, correct?
Yes.
Okay, and you're not her parent, but you have a court order where she's placed with you, and you're a conservator.
Yes.
Okay, and is she related to you?
Yeah, she's my niece.
Okay, and there was some litigation, and she came to live with you, and now you're her lawful legal guardian.
Yes.
Okay.
Can you just state your name again? I don't know that we ever got it clear because
I'm Tina Topsy.
You're Tina Topsy, and
Yes.
you are the legal guardian for
Janai.
Thank you. Go ahead, Mr. Dean.
Okay, and okay, so she was involved in an auto accident that occurred around August 28, 2023. Is that right?
Yes.
Okay. And she was actually transported to the emergency room as a result, right?
Yes, sir.
By ambulance. Okay. She was treated there, and then there was some follow-up with chiropractic care.
Yes.
And as far as you know, has she fully recovered?
Yeah, she's fully recovered.
Okay. Okay, so it looks like the settlement in this case would be for a total of $16,800 for your, I want to say child, but for Ms. Topsy. And of that, there's $8,600 in medical fees, and 1/3 of that, the 1/3 of the 16,800 is going to attorney's fees, or 33.33%, for a net total of $5,203.45. Does that sound familiar?
Yeah, that's
Okay.
familiar.
And that would be deposited with the court's registry until she turns 18.
Yes, sir.
Okay. And again, it's been a little while because we've been to court before, but we talked about this some months ago. I talked to you, right?
Yes, you did.
And you talked to, obviously your attorney.
Yes.
And we talked about the fact that you could go to trial on this. You don't have to settle.
Right.
Okay. And at trial, you could get more, you could get less. It's up to the fact finder, right?
Right.
And I think the big deal about settling is if, 5, 10, 50 years from now, if some injury were to come back or resurface, or some new injury would come to light, you're limited to what you settle for, right?
Right.
Okay, so this is the final deal, and you fully understand that. Okay, so okay, so I'm sorry, my alarm went off. It just threw me for a second. Is it your opinion that this is in the best interest of the child to settle this case?
Yes, it is.
Okay. And are you asking for the court to approve the settlement?
Yes, I am.
Okay, I'll pass the witness.
Any questions for this witness, Ms. Crow or Ms. Nyack?
Yes, Your Honor. I just have a clarification question. Ms. Topsy, is it your understanding that $5,743.25 is the amount that will be paid to cover the medical expenses?
Yes.
And that the balance remaining after attorney fees have been removed from the 16,800, the amount that will actually be deposited into the court's registry on behalf of Jenna is $5,203.45. Is that your understanding?
Yes.
And is it your desire to have the court approve this settlement on behalf of young Miss?
Yes.
Thank you. I'll pass the witness.
I have no questions, Your Honor.
Thanks to both of the witnesses. I don't have any questions for either of one of you yet. I don't think I do, but let me make sure that everything's proper with Mr. Dean. Mr. Dean, is this a reasonable and fair settlement for each child?
Yes, Your Honor, it is.
And something that you need to understand is if this money gets put in the registry of the court, it's on you as the guardian ad litem to follow it through and to make sure it gets properly deposited in the right account. Do you understand that?
Yes, I do.
There's some extra paperwork you need to fill out if you want it to make sure that it goes into the right account and that they earn interest on it. I am telling you this and asking you and making sure you understand that. Do you get
Yes,
it?
Your Honor. I understand that I need Social Security numbers from everybody and I need W-9s and then I need to go online and set up the account.
Great. We've been having some issues with that. And so I feel like I need to clarify when it goes
Sure.
in the registry, there's more work to be done. It doesn't just magically happen. It does require some paperwork by the two guardians in this instance, just to make sure it gets properly deposited in the right way and that you're earning interest on that money or your child's earning interest on that money and not the county. It just requires some additional paperwork. It's an accounting thing. It should be easier perhaps, but it is not. And so that's what has to be done. And then how much is your fee for this, Mr. Dean?
It was $750, Your Honor.
For both?
Yes.
And that's going to be paid for by Ms. Crow's client?
No, it would be paid for by the defendant or the coverage.
Right, Ms. Crow's client, right?
Oh, yes.
Yes, Your
I'm
Honor.
sorry.
So, and I'll write that in.
Thank you, Your Honor.
And having heard the evidence, the court is going to approve this settlement on behalf of both JO and SS and the amounts therein in order to be deposited in the registry of the court. Order a $750 fee to Mr. Dean, payable by the defendants. And then we will wish you the best of luck to these two children, and we can go off the record at this time. Thank you.
Thank you.
Thank you, Your Honor.
Then where are we on finding the guardian in Flores and Santa Cruz?
Still nothing, Your Honor.
Okay, then is it time for y'all to be excused, or what do you want to do here?
I mean, if you wouldn't mind, it sounds like you still have one more hearing to go through. I'd say let's just hold off and see if we can get her on by the time that's done, and then if not, obviously we'll.
You'll have to reset, I think.
Yep.
Yeah. All right, then we will do the continuance next. I'll let Ms. Roccanelli tell me when she's ready.
Thank you, Judge. I'm ready.
Then going on the record, this is Stephen McCrary versus Cameron Alcedo. Let me take attorney announcements for the record.
Leslie Warren is here for the plaintiff, Your Honor.
Jay McGregor, I'm here for defendant Cameron Alcedo, Your Honor.
And then one of you has filed a verified motion for continuance, and you may argue it at this time.
Thank you, Judge. This is Jay McGregor. I represent Ms. Alcedo. She is a college student at the University of Arkansas. This case is currently set for trial this month, later on this month, June 23rd. Originally, when I was handling this case, her father told me to just set it for trial anytime during the summer that she would be available. That was quite a while ago. She has since signed up and is now overseas for a study abroad course. I have filed an affidavit signed by her, and I'm going to ask that that be admitted as Defendant's Exhibit 1.
No objection.
Defendants 1 is hereby admitted.
And so her affidavit says, Judge, that she is in Austria from May 25th, 2025 through June 28th, 2025, taking study abroad courses in psychology. She's prepaid. Obviously, she's already over there. It's non-refundable. The main thing is that if she took away from that class, it would jeopardize when she's going to graduate from the University of Arkansas. I apologize for not finding out about this earlier. This is our first trial setting. It's my first motion for continuance. I'm not asking for a long continuance. I've talked with plaintiff's counsel, and we're both available on September 22nd of this year is a good date for both of us, which is not too far off. So I'm asking for a continuance of this trial setting until September 22nd, 2025. The other reason I'm asking for it, besides my client being out of the country, is plaintiff's attorney has filed a motion for summary judgment kind of at the last minute. There's one witness to this accident that I would like to take the deposition of to support my response to the motion for summary judgment. Her name's Ariel Turner. I listed her as a witness on May 9th of this year, but we found out about her for the first time when we took the plaintiff's deposition. This was a motorcycle versus car accident, and the plaintiff has admitted he was possibly speeding, and she was behind him with a group of other motorcycle riders. So her testimony could be very pertinent to the summary judgment motion. So I need to take that deposition between now and September so I can respond. I was going to call her live to trial, Judge, but now there's a motion for summary judgment. So those are the two reasons I'm asking for a short continuance until September 22nd. I would ask that we just have a new scheduling order with a new discovery deadline and, deadlines for all the trial documents.
So you're not just asking for a continuance of the trial then, you're asking for a whole new scheduling order. Those are very different things.
Correct.
It was portrayed originally as I just can't do this because my client's out of town. But now you want discovery to stay open.
For one deposition.
Well, but that's not what you just said. You then said you want all new deadlines in the scheduling order.
All I'm planning on doing is taking one deposition. No new experts, no anything. However you would like to put it in an order. I just need that one deposition to respond to the summary judgment. I don't anticipate any other discovery doing anything else, Your Honor.
Was this person whose deposition you need, have they been listed from the beginning as a person in the with knowledge of facts and the disclosures?
Not by plaintiff, even though they've known about him. Obviously, she was at the scene. She talked with the plaintiff. He's the one that had her information. I didn't find out about her until the depot. That depot's been quite a while, but I've listed her in my discovery responses, and Mrs. Warren never has. She's never listed her as a person with knowledge of relevant facts, even though they're friends, plaintiff and Mrs. Turner. So that's all I'm asking for. My client's out of the country, continuance. When I talked with Mrs. Warren, she told me she couldn't agree, but she wouldn't oppose. And now it appears she's changed her mind and is opposed. We talked out in the hall after another hearing not too long ago, and she told me she wasn't opposed, but couldn't agree. So all I need is that one deposition and trial on September 22nd. We'll be ready to go, Judge.
All right, Ms. Warren.
Your Honor, a few things. I am not opposed to the actual continuance because she's out of the country now, the defendant, the party. I am opposed to reopening discovery. I do not feel that the Ariel Turner has been disclosed timely enough to be called for trial. I also don't feel that he's shown that her evidence would be material or any due diligence on his behalf to obtain her any evidence that she might have provided earlier. With regards to my summary judgment motion, it was filed at least 28 days prior to the current hearing setting, which is the 11th of this month. So it wasn't really last minute. So I would let the court know that I am not opposing the actual continuance, mostly by force of hand. I am available September 23rd. I haven't checked with my client on that, but I will. And I would ask this court to deny any reopening of discovery in this matter, aside from supplements at least 30 days prior to the actual trial.
Thank you. Okay, here's a few things. For those of you who've been attending my basically bi-monthly docket call of the jury trial docket, people would be noticed of this. Mr. McGregor, you should understand that the legislature now requires every judge in the top 6 counties to log every single continuance they grant and to log what attorney they grant it for. Imagine the reporting that the legislature is requiring on urban judges because they want to micromanage the work that we do. It does put people with very reasonable motions to continue trials in a difficult position, because it puts me in a difficult position. I need attorneys to understand that this report, it's called 1182 reporting, has unintentional consequences on reasonable requests for continuance. I do not think the legislature intended reasonable requests for continuances that are basically agreed to get caught up into this. But nevertheless, that is what every single judge who is a judge in one of the top 6 counties is dealing with. So I want people to understand it. I want the bar to understand how difficult of a situation this puts trial judges in, who has to log reasonable continuances, reasonable ones that are basically agreed. It is a very uncomfortable thing for trial judges across this, trial judges in the top 6 counties. The other part is it's just the top 6 counties. It's not McLennan County. It's not judges in all the other counties. So you kind of come into the urban counties and you're like, what is going on? In my opinion, too, you know, they've done all of these tort reform efforts, and this actually is antithetical to that, because it's causing judges to not grant reasonable requests, to try to drag things to trial. So please understand what is going on. That said, this is a reasonable request. It's basically agreed to, and I'm going to agree to the continuance, and I'm going to sign off on it. But I'm not going to sign off on the additional deposition, and we're not going to kick the motion for summary judgments that's set, because it looks like it's set on Thursday or maybe even Wednesday.
Wednesday, Your Honor.
And I don't think that this is a reason to not hear the motion for summary judgment. I don't want it to get delayed anymore. And I feel like if I grant you this ability to take this witness, then you're going to go to the judge and try to push the summary judgment hearing. The summary judgment needs to be heard on Wednesday, and we'll hear the trial in September. You'll need to call court administration, Ms. Warren, and make sure it gets reset. That's not me, that's court administration. But Mr. McGregor, I will grant the continuance, but I want you all to understand that when you bring these kind of almost agreed to continuance motions, you risk judges saying no, especially judges who maybe haven't been on the bench as long as I have, who are worried about their reporting, because the legislature has put some pretty serious restraints and some pretty big brother restrictions on trial judges in these top 6 counties. So just be aware of that, understand that. I will grant this motion for continuance. I will not extend any other deadlines. All the other deadlines stay, but we'll move this trial in September.
I appreciate that, Judge. How about pretrial deadlines and stuff like that? Can we do a schedule?
All that moves. The things that kick in, like exhibit lists and witness lists and things like that, that all needs to move as well.
Okay, so we'll do an agreed scheduling order with just all those trial exhibits and deadlines and things.
Thank you.
Okay. Thank you, Judge.
Send it to me, that email address that I said in the beginning, the 201.submission@traviscountytx.gov. That's the email you send it to.
Okay, great. Thank you, Judge.
Thank you.
Thank you, John. We actually sent the orders previously to this hearing.
Okay, well, I'll look at it. I mean, I don't know if you did. It sounds like you got to make some changes to maybe what you send in on a scheduling order. So maybe look back at it and try to agree to form, even if you can't agree on substance, if you could both put your agreement to it as to form.
Okay.
All right.
Absolutely.
Great, thank you.
You're excused. We can go off the record.
All right. Thank you.
Thank you.
McCrary versus Alcedo.
Good afternoon, Your Honor. Again, Leslie Warren here for the plaintiff. And we were requesting a record.
For a summary judgment, you're not entitled to a record. It's all on the, it's just on the pleadings. I mean, that's why I asked you if you had objections. I'd certainly take a record of the argument of that, but
understood.
Summary judgment, I must decide based only on the pleadings and the summary judgment evidence. Sorry, not
No
entitled.
worries. Before I go into the facts of this motion, have you had a chance to review it at all so I don't waste any of your time?
I have reviewed it briefly, but you should go ahead and make your full presentation.
Okay. Your Honor, this is a motor vehicle crash that is a SUV versus a motorcycle. The facts of the case on the record show that the defendant was, let me back up. The road they were on is 2 lanes for a portion of it, and then 1 lane for another portion. It's on a hill with steep gradation. My client was on his motorcycle in the outer lane, and I'm sorry, yeah, in the outer lane, and Miss Alcedo, I believe, was right in front of him. And then she decided to go from that outer lane to make a left or a U-turn. That part's still out, and he crashed into her. Defendant has alleged in his answer, or for amended answer, that the affirmative defenses of contributory negligence and proportionate responsibility. And in order to prove those and be able to claim those to the jury, the defendant has a burden of proof, just as I would in presenting my claims. With regards to proportionate responsibility, there is no automatic right to that. The defendant must prove that the plaintiff was not only negligent in violating some duty, but that negligence on the part of plaintiff somehow proximately caused or contributed to the subject injury-producing incident. In other words, where the plaintiff's act does nothing more than furnish or give rise to a reason by which the plaintiff injury is made possible, that alone cannot be the basis for a potential defense of contributory negligence unless such acts are also negligent. Essentially, in other words, the proportionate responsibility must be proven that but for plaintiffs, in this case, negligence, the injury-producing incident would not have occurred.
Ms. Warren, I'm sorry, I'm going to interrupt you and I apologize, but I see that Mr. Jimenez is in the waiting room. And with your permission, and because I have a court reporter standing by, I'm going to take up their very brief motion for continuance so that I can then let Ms. Mata go, who I'm sure has other things she needs to be working on.
Absolutely.
So, okay. I'm going to ask you and Mr. McGregor to turn off your cameras while I take up this other matter. Thank you, and Ms. Warren, Mr. McGregor, I apologize for interrupting you, but I knew that wouldn't take very long, and I hated to make them wait.
No worries.
All right,
No
so
problem.
Ms. Warren, you can continue your argument.
In defendant's, thank you, Your Honor. In defendant's amended answer, he provides several reasons for why he believes that plaintiff was contributorily negligent to causing this incident. He names that my client was speeding. He alleges my client was passing when unsafe to do so, failure to maintain a driver's license and failure to maintain a motorcycle license, failure to keep a proper lookout, failure to use due caution, failure to timely apply brakes, failure to take proper evasive action, driver inattention, failure to maintain safe following distance, and then driving the vehicle in a willful or wanton disregard for safety of persons or property. In my motion, I go through each one in kind. With regards to speeding, my client was asked about that by Mr. McGregor in his own deposition. Mr. McGregor asks, all right, this says patient was reportedly, under history and present illness, it says patient was reportedly helmeted, jacketed, and presumably riding a motorcycle traveling 40 to 50 miles an hour. Do you see that? My client says, yes. Mr. McGregor, would that information most likely have come from you? My client says, yes, sir. Mr. McGregor, it goes on to say he believes he had slowed down a little bit before impact and was going 30 to 40 miles an hour at that time. Do you see that? He says, yes. Would that information have come from you? Yes. Is that what you at the time believed you were able to slow down to, 30 to 40 miles an hour? He says, correct. The speed limit of that particular area is 40 miles an hour. My client testifies that maybe he was going anywhere between 40 and 50 at the time of the incident, but there's no indication he was actually speeding. And even if one could possibly see that he might have been speeding to some extent, there's no evidence that that proximately caused the subject incident in any way. And the reason is we will go down further, and this addresses passing when unsafe to do so. Mr. McGregor asks my client to say in his own words, tell me how the accident happened. And this is in my client's deposition. My client says it was a left at the light onto Courtyard Road. I believe that is what it was called. And then I started heading westbound. And there's 2 lanes headed westbound and 1 opposing lane. The lane I was in would be the middle lane. I'll call that lane number 1. Lane number 2 would be the right lane. And oncoming traffic, we'll just call that the oncoming traffic lane. I was in lane number 1. I was coming up at that point. I was headed, it's downhill there. And Cameron was in lane number 2. As soon as I seen her, I didn't know that she was turning. She threw on, she was in lane number 2 and turned her blink on. It blinked exactly 1 time, and then she crossed over my lane, lane number 1, to make a U-turn. Well, we don't know what, but to cross over my lane, and I couldn't stop, and I ended up T-boning her, and we both ended up in oncoming traffic. He goes on further to say, I guess that she wanted to get into the driveway right there, and she crossed over into my lane. The point of the matter is I had mistakenly labeled where each party was before, Your Honor. Lane number 1 is the one that is closest to the left. Lane number 2 is the one farther to the right. And so Miss Alcedo actually crossed over into his lane and to go into a driveway to the left of where they were traveling. Moreover, the actual defendant actually corroborated my client's testimony. And I asked her, I said, in this narrative in the police report, it says you were traveling westbound along the 5800 block of City Park Road. My client was mistaken on what it was called, in number 2 lane. Unit 1 attempted to make a left turn into a private drive from the number 2 lane. As Unit 1 completed this maneuver, Unit 2 was traveling in the lane directly adjacent. And Unit 1's unsafe turn from the wrong lane caused 2 to collide with its front left quarter panel. And she says, if I'm looking at the photo to the right of that, I don't believe that's where my car was. And then I ask, you don't believe that you were turning? She says, I was turning left. I'm in the furthest lane. Is that where I crossed over the left, over the oncoming lane? I said, that's my understanding. She goes, yeah, I think my car was a little further turned when the impact occurred. I think that's correct. Yeah, I think that's right. In other words, Your Honor, the record shows that plaintiff and defendant both agree on how the crash occurred, in that defendant attempted to make a left turn from the outer westbound lane instead of from the nearest westbound lane to the desired turning area. And but for that move from the wrong lane, this crash would not have occurred. With regards to failing to maintain a driver's license and motorcycle license, the fact that plaintiff does not have a driver's license or motorcycle license and did not have one at the time of the crash does not, as a matter of law, make a driver liable or constitute proximate cause of a collision. And I have the case law is Medina
No,
versus.
the court's aware of that, but how can you move for summary judgment on that?
Exactly.
I mean, that may be, but that's something he can plead. I mean,
You could, sorry.
But you, how do you get to a summary judgment on that issue?
Because because it did not contribute to the cause of the crash. And the defendant must prove that it was negligence and also that it was a proximate cause of the crash. And he cannot prove, there is no evidence on the record that the fact that my client had no motorcycle license at the time and no driver's license at the time was a proximate cause of the subject crash. Would you like me to continue, Your Honor?
Yeah, and if you want to just make your argument, I don't need you to read me the summary judgment evidence, which I will certainly consider myself, you know, I'm going to have to do that myself. But
failure to keep a proper lookout and use due caution. There is no evidence that my client failed to keep a lookout at all. According to the defendant, she never saw him until the impact, which would indicate if anyone failed to keep a proper lookout, it was Miss Alcedo. Also, the defendant was provided discovery requests where I asked him to provide facts that substantiate his each of those affirmative or claims for contribution, proportionate responsibility, and he did not answer them. He objected. There's no evidence that my client failed to timely apply his brakes or take proper evasive action, and there's no evidence that he was inattentive while he was driving. As for following too closely, there's no evidence of that either. Mr. McGregor claims that he was riding far, far in advance of all the other motorcyclists that were with him that day. However, they were riding in formation where there's a lookout that's further above the rest, and the rest of the riders in that group are staggered. In short, as a result of there not being any evidence of the foregoing, there's also no evidence that my client was operating his motorcycle in any willful or wanton disregard for the safety of people or property. And as such, we ask that the court grant plaintiffs' motion for summary judgment on on defendants' affirmative defenses of proportionate responsibility and contributory negligence, because none of the things that Mr. McGregor has alleged in his pleading can fulfill both elements of the requirement. And again, that being that there was negligence and that negligence proximately caused the subject crash.
thank you, Mr. McGregor.
Thank you, Judge. First thing I need to address, I filed as part of my motion a motion for continuance of this actual hearing. We had a hearing, I believe, on maybe Monday about a continuance of the trial setting, which was granted. And the judge at that time said that my motion for continuance of this hearing would not be granted, but she did not hear that issue. She just said she didn't think it would be granted. So the reason I'm asking for continuance, I just want to get it on the record, Judge, that I'm asking for continuance of this hearing because there was a witness to this event, an Ariel Turner, that saw everything. She was one of the motorcycle drivers. I was going to call her live to trial, and this motion for summary judgment was filed at the very last minute after discovery was basically substantially completed, if not the deadline had already passed. Mrs. Turner would know about, the motorcycles, the actions of everybody in front of her. She was the closest one, even though she was 30 or 40 yards away. But I would like to take her deposition in order to respond to this motion. So that's why I'd filed a motion for continuance. So I would ask that issue be addressed first, and then I'll be happy to respond to the rest of the motion.
I see that Ms. Warren has filed, as of 2 days ago, a trial notice for September 22nd, correct?
That's correct, Your Honor.
Ms. Warren, your trial notice is, you say it's going to be tried before the 250th Judicial District Court. It's filed in the 250th. You may never see that, Judge. That's an improper notice, so you probably want to get that.
Okay.
We work on a central docket. There's a form notice on the court's website, so you ought to look at that. But,
okay. I apologize. May I respond, Your Honor, to the continuance?
Well, hold on. Then let me ask you another question. The next question is there a scheduling order?
There is.
There is not currently.
There
There
was.
is, but there was. It would be the answer. Yes, and the judge ordered no new discovery on this issue, basically. But we don't have that order signed yet.
Yeah, I can see her. Well, I don't see a docket note. What judge were you in front of? I don't see a docket note on.
Judge Meachum?
Yeah.
You didn't make a docket entry. The last docket entry is from April when you were there on your motion to compel, but there wasn't proper notice given.
Correct.
So there's no order. She said no new discovery.
She said no new discovery.
So
Correct.
your continuance is based on the fact that you want to do some discovery that Judge Meachum has said you can't do?
Exactly. And I don't know who's going to be hearing the case and how all that plays into it or not. I know you're hearing this, and I was asking for continuance of this hearing for that basis. And
But the only basis is to do more discovery that Judge Meachum has said you can't do.
Correct. I'm just trying to get all that on the record, Judge.
Then your continuance is denied.
Okay, thank you. In response to the motion for summary judgment, I think the facts are really important. This is a motorcycle rider overtaking my client as she's slowing down to make a left turn. So he's coming up from behind her at a faster rate of speed and attempting to go around her. Those facts are important. In response, we've claimed proportionate responsibility, the negligence of the plaintiff. Is there a genuine issue of fact regarding his negligence? Yes. As the court knows, we don't have to marshal all of our evidence. I don't have to win the trial at this point. I simply need to raise a fact issue with all of the evidence being construed in favor of my client. And we have certainly attached to our response more than a scintilla of evidence of the potential negligence. At this point, I would ask that my exhibits D1 through D4 be admitted to the.
Well, if they're attached to your motion to summary your response, they'll be considered.
Great. Thank you, Judge. So we've claimed negligence and negligence per se both. The first issue basically is the speeding of the plaintiff. And so we've obviously negligence per se under Transportation Code 545-351. An operator may not drive at a speed greater than is reasonable and prudent under the circumstances than existing, and then just the basic negligence standard for the same thing. The plaintiff has admitted in his deposition. I asked him, your medical records state that you were driving up to 50 miles an hour. Is that what you recall? And he said, it was a guess. I told the cop, yes. You agree that it's possible that you were speeding, exceeding the speed limit of 40 miles an hour, though. Like I said, I wasn't looking, so yeah. And then I asked him about in the medical records, would it be safe to say that any guesses on speed would have come from you? He said yes. And then so we've got basically his testimony that he was traveling up to 50 miles an hour in a 40-mile-an-hour zone immediately before the impact. We also have both his medical records, or those are two of my 4 exhibits. The EMS records, Your Honor, he told them that he was going between 40 and 50 miles an hour. And then when he was taken to Seton emergency room, those records also say that he was going possibly up to 50 miles an hour. So I think I've got him there on possibly speeding. It's certainly enough for the jury to hear that and make a determination when he's overtaking somebody from behind. I don't know what else I would need other than an admission from the plaintiff in his medical records and in his deposition testimony that, yes, it's possible I was speeding. That's an allegation we made. He was speeding, and he's admitted that is a possibility, and his medical records certainly confirm that is a possibility. I think that's enough to defeat the summary judgment right there on the whole issue. And going on to, did it cause any injury? In his testimony and his medical records all talk about the fact that when he hit my client's vehicle, he flew over the hood. That certainly gives the jury some indication that he was traveling at a certain speed. You know, they can certainly look at that. The EMS records talk about that the trauma activation it was called a trauma activation due to the speed around 40 or 50, meaning they upped the response time basically. The ER records say he was a jacketed motorcyclist traveling 40, 50 miles per hour, flipped over the vehicle's hood. So both of those go together, Judge. He was speeding, and it's obvious the jury can see with flipping over the hood, that takes some speed that could lead to the injuries that he's claiming. So I think there's causation issues there that the jury can obviously take up. With the illegal passing, my client testified that the police report does not accurately show where her vehicle was located. She said, "I do not believe that's where my car was." And she says that she was I was turning left, and that I was crossing over into the incoming lane. There's no testimony directly from her that she was in the right lane versus the left lane. Her testimony is about as clear as mud from plaintiff's counsel in the deposition. She says, though, that she has an opinion of the accident, and this is in the evidence, that he was trying to pass me in the oncoming lane. I may have been going too slow. He was much further in front of his other buddies because they were all traveling together, but he wasn't with his group. That's my client's testimony on how she believes the automobile accident happened. So I believe that gets us enough there on passing to the right, because the plaintiff also agrees that his testimony, you tried to go to the left, and you said that when the impact happened, your bike was somewhere close to the double yellow line, correct? And so her vehicle, which would be my client's vehicle at that point, part of it would have been over the yellow line. And he said, correct. So all that testimony together, the jury can come to the conclusion that he was passing in the oncoming lane of traffic. With regard to the driver's license issue, Your Honor, I'll talk about it briefly. I think we've got enough on that. I asked him when this accident happened, did you have a valid Texas driver's license? No. Have you ever had a valid driver's license of any kind? No. Have you ever taken any driver education class? No. Have you ever taken any driving exam? No. And obviously, if you didn't have a driver's license, it's safe to say you've never had a motorcycle driver's license. Correct. Have you taken any courses about how to drive a motorcycle? No. Beyond that, he got a ticket in this case for the motorcycle not having it, just proves that he didn't have it. And then regarding his experience driving a motorcycle, which becomes relevant also. How long had you been riding motorcycles in general before the 2021 accident? So he's had 2 motorcycle accidents. He's been driving about a year and a half. Motorcycles is his testimony. So he had a motorcycle for a while, had an accident, then he didn't have a motorcycle until he got this one and had a second accident. So in a year and a half, that's his total time driving motorcycles without a license, and he's had 2 accidents. So the jury can take that all into consideration there. So Judge, I think we've got enough on all of these issues, but certainly on negligence and negligence per se on speeding to defeat the summary judgment motion. So we ask that it be denied.
Thank you. Ms. Horn, you may close the argument.
Your Honor, all that I would say is that the fact that I pointed out that the road in that area switches from just 2 lanes, 1 going each way, to 3 lanes, 2 going westbound, 1 going eastbound, is relevant here because
what summary judgment evidence do you have about that fact?
About that fact? Their deposition testimony.
Okay, you point out that deposition testimony to me in your motion?
I do, Your Honor.
Okay.
And so what Ms. Alcedo believed was oncoming traffic light was not. It was the lane closest to the left turn, which is the one she should have used if she wanted to make a left turn. That's, other than that, I don't believe that there's anything in the record before us that shows that my client not having a motorcycle license contributed proximately to this crash.
From hearing it, I've only skimmed the motion and the response, but I do think your client does make some admissions about how fast 40 to 50, which would be speeding, which I think is a scintilla of evidence about that. And that gets you to proportionate responsibility. All he has to do is point a scintilla of evidence. He didn't have to prove it. It gets to the jury.
Even though that scintilla of evidence says it's a guess?
Yep. All anybody's going to have is a guess. We don't have, right? That's how most car wrecks are. Nobody has, it recorded. That's some evidence. That's his guess. That's some evidence.
And the other thing I would point out is that Mr. Mark McCrary, when he made that guesstimate, was on 100 micrograms of fentanyl, which I think
that goes to the credibility of the witness. It doesn't get you a summary judgment, or it does, that is enough to defeat your request for summary judgment on that issue.
Okay.
I mean, it seems to me these are all fact issues. I will look at it, but I will say, from as I sit today and hearing the argument, I'm not sure you're going to get there on summary judgment. I think Mr. McGregor has pointed out scintillas of evidence that would get this case to the jury. But I'll look at it and get it to you quickly. Has anybody prepared a proposed order?
Yes, Your Honor. I submitted a proposed order to through email to your submission.
Yeah,
Okay.
I can submit one to you, Judge, that denies it. I'm sure hers says it's granted.
Okay, well, either of you, I like them when they're in Word, so I can make any modifications I want to make. All right, I'll get you that. But Ms. Warren, I would encourage you to look at the Travis County on the website, our court's website, about proper notice, because we are in a central docket, and your notice for the jury trial says you're going to be heard by the 250th. You may never see the judge in the 250th.
Absolutely, Your Honor. I will do that immediately.
Yeah. So I would also encourage anybody who's not familiar with the local rules to look at those, because we get there's confusion when people don't understand the central docket. Okay.
Yes, Your Honor.
Thank you all. You may be
Right. Thank you, Judge.
You may be excused.
Thank you, Your Honor.
Thank you.
So, how are we doing? Still nothing?
We are not doing. Looks like we'll have to get reset, unfortunately.
All right, that's fine. You'll need to reset it through court administration. Sound issues with my computer. Good luck. And so instead of fixing the sound issues, the best thing we've come up with for now is that I yell at the screen. So currently our way of fixing our sound issues is I'm yelling. So hopefully it's not terrible and that you're not getting somebody yelling at you. I'm probably going to lose my voice at some point, but for now, that is how we have fixed and rectified our sound problems. So if it feels like I'm yelling at you, I'm sorry, but I'm being told by my staff that they're having a difficult time hearing me. So I will do my best to try to make it through these hearings with the sound issues at play. We just haven't been able to fix them, so this is where we are. I have several things set this afternoon. Let me run through who's here on the cases. I want to also get my back end docket up. All right, so I have yes, the J&L framing case. Are y'all here? You're muted, but I see you here.
Yep, gotcha.
Okay. And then what about property doctor services?
Yes, Your Honor. Charmaine Becken here on behalf of the plaintiff.
Okay. And do either of those first two, I think those are kind of coming back to me settings, but do either of those first two need a record?
Property doctors will take a record. Yes, Your Honor.
I believe J&L will need a record too. Yeah.
Okay. All right, thank you. Next, I have a motion for summary judgment for the Madison versus Alvarado cases.
Yes, Your Honor. Brandon Starling on behalf of Level Smart, the defendant in that case.
And Brian Buster, Your Honor, on behalf of the plaintiffs, the respondents. It's a summary judgment, so we don't need a record for that portion. However, they did file a motion to strike, and so I'd like a record for that.
All right, we're probably just getting a record for that, Alicia. That's probably easier. So we'll see. Especially with a 15-minute hearing, that's all y'all announced for. So I'll probably just put the whole thing on the record.
That works, Your Honor.
It's fine with me, Your Honor.
Canada versus iTex.
I'm Evelyn Canada. I'm here. I am pro se.
My name is Andrew Oliver. I'm here on behalf of Ibiza Homes 3 LLC, a defendant in the case.
Mark Sessoms appearing for the rest of the defendants except for Perry Clark.
And Miss Canada, who is your default judgment against?
Perry Clark only. The rest of the defendants aren't of concern as of today. This is just a
We're not
default.
arguing it yet. I just wanted to know, and we can confirm that the Perry Clark person has not filed an answer, even though you've served him.
Correct.
Okay, we'll get to that when we get to it. I just was curious what the posture was, and there's nobody named Perry Clark that's here. Do any of the other defendants know who this person is?
We don't have knowledge of who he is, Your Honor, but I believe he does have an answer on file.
Okay. Well, we'll look at that when we get to that. Thank you. And the last thing is Williams versus Franks.
Yes, Your Honor, I'm the movement. It's a motion for continuance. I think everybody's here.
Yes, Your Honor. Greg Cotton for the plaintiff. Jeff Williams. I'm here as well.
And Shantae Collins for Tyrone Sanders as heir of the estate of Tanya Lee Sanders.
And that's a motion for continuance?
That's correct, Your Honor. Partially opposed. Co-defendant doesn't oppose. Mr. Cotton couldn't agree. I don't know if he's really here to argue in opposition, but we'll get to that. It's a first continuance.
Okay. I guess it's records for everybody then, Alicia. If I talk at normal level, can y'all hear me or not hear me?
We can hear you, Judge.
Hear you.
I'm still having to project quite a bit, but I'm trying not to yell now. I do now have somebody joining from IT who I'm going to talk at normal. I'm going to actually talk at a normal level now and hope that we can understand if there's a problem. If I'm talking at this normal level, can y'all hear me or can you not hear me? You can still hear me.
Can hear you. Yes.
But Miss Roccanelli, is it quiet or is it at normal now?
It's quiet.
Okay, and we have everything, just so the IT person knows who's on, we have everything up, dialed up to the absolute highest. And we've never had this particular problem before today, where when we came back from a bunch of updates, my Zoom didn't appear to come back at the same level. The audio. Don't know why, never happened before, but this is, maybe it's the third type of problem we've been having with Zoom. But we're going to go forward with our hearings. I think, Ms. Roccanelli, you can hear me enough.
Yes, and was it Madison we're starting with?
We're starting with the J&L framing.
Oh, I'm sorry, Judge. I thought we were gonna, I'm sorry. I need to open that one up. I was thinking let me just get out of this and open up that one.
Okay, on the first case, which is the J&L framing case, Mr. Howarth, are you here?
Yes, Your Honor.
I'm looking at this case and I'm finding there's an original answer in the file. Have you seen that yet?
I did see that came in on Friday, I think, last week.
So I think then we can't grant the default judgment.
Well, I mean, obviously it was filed, I think I calculated 312 days too late, but I understand the court feels it may not be allowed to issue the default. I would say in that instance that if the court's not willing to go that far, that we have the separate motion that was filed in our original pleading, which is for the summary removal of the lien. And if the court doesn't want to deal with the default issue, I'd request that we at least be heard on that.
do you not feel like you need to give him notice?
For the
I just have it listed as a motion for default judgment.
um
I don't, I need to look and see. Let me see. I don't, this is all happening in real time. I just noticed the answer just now. So I think we need to set it with notice, have a hearing where Mr. Cruz is noticed, and there is a hearing set that's like notice of hearing to remove lien or whatever you call that. Clear title, whatever the motion is going to be. I think
well,
that's
if I could, for just a moment, we did give him notice of this hearing happening. Now that was before his answer was filed. And you can see that in the materials for judge folder in the box account. And we not only we sent it to him personally at his last known address, we sent it to the attorney who helped him record the lien. I think as the court requested a while back.
well, here's how for me, I don't think I can proceed. There's now an answer in the file. It's going back to central docket though. It doesn't come to me. It would be a central docket setting that you need to set through court administration. I mean, I'll hear it if you want me to. But I was thinking it would go back to central docket. That's our kind of, since there's now been an answer filed. But if you want it to come back to me, but I'm going to need that's a you choice. You can choose. I'll either keep it or we can set it back on central docket. You can tell me which one you would prefer. And then we need to have notice to him of a notice. Well, a motion needs to be filed to remove the lien. It needs to be called that, I think.
Well,
and then that needs to be set.
Well, that was filed with plaintiff's amended petition.
Right, I know. Well, then if you think it's already then part of the amended petition, then just set it and do a notice of hearing for, I would leave that. I just worry if I'm going to send you back to central docket, you might want to have your own separate motion. Because I think that's or set it for final trial. If that's the other thing you could do is you could just set this for final. If that's the main point to the final now, you could go ahead and give him 45 days notice of a final trial. And I think that's perhaps what you should do.
Okay.
I mean, it's up to you, but I think you have to reset this and give him notice.
Okay. So is the court saying that the notice that we did send was insufficient to notify him of the hearing on the motion for summary removal of the lien?
There's no notice in the file. What notice do you think you sent? What notice do you want me to look at?
Let me pull it up. You're in the box account, I presume.
I am not in the box. I'm in the record with the clerk's office because that would be the official notice that any appellate court would see. They would go to the clerk file.
Okay.
The official file for the court.
Okay. In that instance, we did not e-file the notice, but we were instructed by the court's staff that those notices could be uploaded to that box account.
Well, for me to see it, and I'm okay to take a record if that's what you want to do. I'm going to tell you though, I do not feel comfortable proceeding without Mr. Cruz having notice of either a final trial or a notice of a, I don't know what you'd call the hearing, but notice to clear title. Like, I don't know what is how can you describe your motion?
Well, the motion is laid out by the statute. It's
I know,
a summary
but I'm
motion.
just saying, what do you call it? I'm asking you.
It's a summary motion to remove the invalid lien is what it's called.
Okay. Summary motion to remove invalid lien. Then I think
That's
that's
right.
what you need to set. And you need to make, and I know this is confusing. It's difficult to deal with pro se parties. I understand that. But I think that's what you need to set is summary motion to remove invalid lien. Is that what you called it?
That's correct.
I think you need to set that, and then you need to give him notice of that setting. And then you should set that on the central docket.
Okay.
Unless you're asking that I hear it, and then I can hear it, but probably set it on central.
Well, I would request that the court hears that today if you're
No,
open
I'm
to
not
it.
going to
Yeah.
hear it today. I'll hear it after notice is given.
Okay. Okay. I understand. I
Yeah.
understand.
But I don't have to hear it because I can tell you're a little frustrated with me. But so I'm happy to send it back to the central docket, in which case you would get any judge, and any judge would have a reset in this case. But I don't know how else to strongly suggest to you, because believe it or not, when it comes to this issue and default judgments, I think I'm one of the easier ones to deal with. And so I'm trying to help you. I would file a motion, exactly what you called it, a separate motion. That's summary motion to remove invalid lien. I would put notice in that motion, and I would make sure Mr. Cruz is served with that. And then I would come to make a setting that you can be at, serve him with it, and come to court in person, perhaps, and do it that way.
Okay, understood. And I want to be clear. I'm not frustrated. I just wanted to be absolutely clear. I mean, this is, I think, our third or fourth reset on this.
It is, and
Yeah.
he filed an answer, and
Yeah.
so now we're at that point, and I recognize it makes it difficult, but it means I cannot grant a default judgment. And given that it's been some weird notice, and I understand you were trying to do what perhaps you thought I wanted, and I do want to see the notice, but the notice itself also needs to be part of the clerk's record. Because if you can't see that it's in the clerk's record, then you can't show that he got notice.
Right.
So
Okay.
now we just have to follow that proper legal procedure of Rule 21.
Okay. All right.
Okay. And you want to
Then
just set it on central?
I'm tempted I'm tempted to bring it back to you since you're already knowledgeable about the case.
I'm happy to take it. I just didn't want to make you have to come back to me because I feel like I'm putting you through a Groundhog Day procedure at this point. But I'm happy to do it. I'm happy to do it. I just need you to file that summary motion in and of itself and put a notice in it that I can see, touch, and feel that went to Mr. Cruz. And I don't know if that's going to be, I mean, he didn't give you let's see what he did in his answer. He gave you an answer.
It was not much. It was a general denial with some sort of verification, which doesn't make sense. Interestingly, it was also e-filed by the attorney that originally helped him file the lien, which I found interesting. I was going to reach out to him, but it's not my job to.
Then I would give, if that's who filed it, if you can see that on e-file Texas or whatever, I would contact him. And I'd be like, I would put that in writing because that's going to help you with me, which is you filed this. He didn't give me an email. That's required by law.
Right.
He didn't give me address. That's required by law. All I have is this thing that you did, lawyer. And this thing that you did, lawyer, I'm letting you know I'm setting this hearing. I don't know how else to do it. If you have any address, physical address for Mr. Cruz, if you have any email address for Mr. Cruz, any efforts to show me that you tried with him would be very helpful.
Okay.
But I'd put it, but also don't just show me, put it in the record of put it in the clerk's record.
Understood.
I think the clerk's
Understood
record
that.
needs to have all of that too.
Okay.
And I'm happy to hear it again. Happy to hear it again. I just,
Okay. Now, so the motion under 53-160 is it by my reading and my understanding of it, there is no standard time frame minimum that we have to give the defendant here.
I don't think it looks like a summary judgment motion to me. It
Right.
looks like it's its own legal thing.
Right,
But
right.
you
So-
still need, but I still think give them, in our system alone, I don't think you could set it just because of the way we do dockets. I don't think you can set it before the week of like June 30th or something. And then
Yeah, I just wanted to be clear that we could
complaints in my
probably set it. I just wanted to be clear that we could probably set it as soon as we file the motion in and of itself by itself.
Yes.
Okay.
I mean, you're clearly more informed about this statute than me, but I'm very, as I've told you before, anytime we're dealing with real property, I have learned in 14 and a half years of doing this, best to not mess it up.
Understood.
Because when you mess up a real property ruling, it is much more headache than a money ruling. A real property ruling is very hard to back out of. So I'm trying to make sure we are correct.
Understood.
Anything you can do to get me to a correct ruling where I feel like this is what we need to legally do, notice has been given, and this is the proper thing to do, and anything you can do to get me there would be great. But the first thing is going to need to be notice. And if he is clearly, I'm looking at this and you're right. I think he is not, they may be watching this because we're on Zoom. I think somebody here has not, but make this in your motion. If they haven't given you something which to notice them, say that in your motion. Like say, I'm trying to give them notice of this hearing, but he filed an answer without putting his address in it. He filed an answer without giving me an email or a phone number. So I still don't know how to contact him. The only contact I have for him is this lawyer who filed it for him, who claims to not represent him, but actually did this, you know, like spell that out for me.
Okay.
I need that sort of story as part of the motion.
Okay.
Okay.
Understood. Understood.
All right. Thank you.
One last thing I would say is the chapter that we're dealing with here does allow for revival of a removed lien. So if, for example, I've been blowing smoke the whole time, and I convinced the court, I duped the court, which I promise I'm not doing, that there is a method by which the claimant can revive the lien. So
thank you for that.
Would
That's
you
helpful.
would you appreciate me also outlining that as an alternative in the motion, or do you just want me to?
And that's his problem, right? If you can convince me that the
Yeah.
law is correct and that the notice has been given and that you have done everything you can to wake this guy up, and clearly now he's probably watching this. That's my guess, and not appearing here, or the lawyer who represents him is. So if you do this again and you put the notice story in the motion, and the notice is part of the record that is the part of the court's record, which is the clerk's record, not my record, then I think we can get to the final judgment or whatever you want me to do here,
Okay.
which is grant summary motion to remove invalid lien.
That's right.
Yes.
That's right.
But prepare the prepare the order that you want me to sign to.
For sure.
And then reset it and then show me notice, and then hopefully we can get to the end.
Understood. Understood.
Okay.
Thank you, Your Honor.
Thanks. Property doctor services is the next.
Yes, Your Honor. Charmaine Becken here on behalf of the plaintiff.
And you would like a record, correct?
Yes, Your Honor, that is correct.
You have a witness here to testify?
I do not, Your Honor. We just have our motion that's been on file. This is I believe we're at the third reset of this hearing. A representative for the defendants who was a non-attorney had appeared at the prior hearing, and it was reset to give him time to hire a lawyer for the corporation.
Okay. I'm looking at my notes because you're right. This is another one that's come back multiple times. And is there anybody else here for Nelson Partners property?
If you're asking me, Your Honor, I do not see anyone associated.
I was also asking the room because I figured if somebody was here, they would say. I have some cell phones that I don't know who they all belong to, so I thought I would ask that.
Of course.
All right, let's go on the record. Ms. Racanelli, are you ready?
I am ready. Would it be okay if people that are not in this hearing could just go off video? That might help me a little bit. Thanks.
Going on the record, this is GN-24-4063, Property Doctor Services LLC versus Nelson Partners Property Management. Let me take the attorney announcement for the record.
Your Honor, Charmaine Becken here on behalf of the plaintiff, Property Doctor Services LLC.
And I think the last time I saw this, somebody tried to show up for the other side. Is that right? And they weren't a lawyer. Is that what happened at the last hearing?
Correct, Your Honor. Mr. Martin Rube showed up as a representative non-lawyer for the defendant in this case at the last hearing that was held on this matter, May 8th, 2025. He was given instructions to find counsel for the named defendant, as a corporation cannot be represented by a non-lawyer. So we followed the court's instructions to reset the case to allow time for that.
And then I see that you also made your record with the district clerk's file, and I can look at and take judicial notice of the file, which has a third notice of hearing on Plaintiff Property Doctor Services LLC motion for default judgment. And it says, pursuant to our instructions, the hearing was reset to today, June 9th at 2 p.m. And how did you, I see you did the notice correctly, but who did you notice? You noticed Mr. Rube, because I think he was there and he took an email. Maybe we had him write his email out for you, but there's something where you gave him email notice of today's hearing, correct?
Correct, Your Honor. Yes, he's received the first, second, and third notices of hearing for this matter. I will say there was a May 28th hearing, but I think there was a schedule conflict for the court at that time. So that's how we got to today.
Right, I don't remember what happened with that, but I think I'm reading that correctly as well. I can't remember what happened, but yes. But you do, and whether or not you gave him first and second notice, it appears you definitely gave him notice for today. I can see it, and I'm taking judicial notice of the file that shows it. And so proceed on your motion for default judgment.
Okay, Your Honor. So this case was filed July 1, 2024. Plaintiff is seeking damages of $30,492.92 in unpaid invoices for turnover services that Property Doctor provided to Nelson for certain multifamily housing units. Under Texas Rule of Civil Procedure 239, the court may render a default judgment on the pleadings against a defendant that has not filed an answer. That's what we have before Your Honor. And when a defendant does not file an answer, all allegations of fact in the plaintiff's petition, except unliquidated damages, are deemed admitted. And I've cited to Dolgan Corp of Texas Incorporated versus Lerma, Texas Supreme Court case of 2009, and breaking down the almost $30,500 amount that I just mentioned earlier. These are services performed to a pursuant to a written contract that was entered in July 1 of 2020. 3 total invoices. I can go through those amounts if we need, but they are attached in our Exhibit E, which is Appendix 138, if you need a pinpoint page there.
I'm going to stop you because you're not admitting exhibits. You actually, though, already made this part of the clerk's record. I see you both filed a motion, but you also filed something called an appendix of evidence in support. And I've been looking at and reviewing the file as you've been talking, and I see that the exhibits are there that you are referring to, and that you have, it appears that all those exhibits are in order, and you also have your invoices as attorney's fees as well, correct?
Correct, Your Honor. And we've provided credits for 2 partial payments that were made as far as the actual damages go. And
it's a liquidated damages clause, basically.
Correct.
And you're asking for $22,615 in reasonable and necessary attorney's fees. Your affidavit says that's reasonable and necessary, but it does seem high given that the amount of damages is only $30,000. So why $22,615?
Yeah, so we are almost a year into this case, Your Honor. The work that was involved for almost a year now was review of the file, investigation of the registered agent information for defendant Nelson, preparation of Property Doctor's demand letter to defendant, preparation of the original petition, including legal research, the preparation I'm sorry, preparation of the petition, including legal research. We coordinated issuance of the citation and service on defendant. There's been a back and forth correspondence with, we've met him before, Mr. Rube, on behalf of the defendant. I won't get into the details, but in an effort to resolve the matter. And we've, of course, had to prepare the motion for default judgment and accompanying exhibits to that. That is the extent of our work. I understand if Your Honor believes that we might need to take a haircut on some of the fees, but it has been pending for almost a year now. And
It's
that's
been pending for a year, but I saw y'all the first time in May. So, so I'm not, what was the delay?
well, again, with the back and forth correspondence with defendant's representative, he had alerted us to a different case in a different state, and we were going back and forth on reviewing some of that stuff and seeing if we could not just come to a resolution on this particular case. He believed it affected this case. He had asked for more time as well to hire a lawyer, and this was prior to any of the hearings we've had before, Your Honor. So that's the extent.
How many hours to get to 22,000 in attorney's fees on a $30,000 damages? How many hours did the lawyers bill?
Well, I would have to refer to my exhibit. We broke it down in two different sections. I'm looking at exhibit F1 and F3, which, if you'll give me a moment, my computer needs to load.
I know mine's in a big PDF and I can't get to like page 200 of the 258 page appendix very easily.
And that's exactly where I was going to go, was appendix page 204 is where this begins.
All right, I'm reviewing it. I'll grant it. And I'm going to grant it as you have provided to the court, including the reasonable and necessary attorney's fees that you are attesting to. I'm going to sign off the default judgment and I will get it filed. And if we put it in this basically in-person box for the clerk's office, so if you don't see it for a couple of days, please let our submission docket know and we'll try to find it. But they should pick it up this afternoon and get it processed tomorrow.
Understood, Your Honor. And the submission docket, is that the 201 email address that I sent the proposed?
Yes, if you don't see it, email us. But check first. I think it should be there within 48 hours. But if for some reason you don't see it, let us know.
Understood.
Okay.
Thank you, Your Honor. May I be excused?
You may, and we can go off the record.
Thank you.
How's my sound doing? Is it any better at all?
I can hear you just fine, Your Honor.
Same, Your Honor.
I'm probably the one we have to worry about, actually, from what I've been told by
Right.
Alicia.
I just is it still feeling a little quieter, Alicia? I'm going to talk very normal now, and we'll see what happens. Because partly because I'm losing my voice because I've been yelling at a computer screen.
Okay, and I'm ready, Judge. Thank you.
All right, thank you. Okay, going on the record, Natasha Madison and Thomas Madison versus Francisco Alvarado, Richard Bond, Investor's Choice, and Levels Smart. Let me take attorney announcements and who you represent for the record.
Good afternoon, Your Honor. My name is Brandon Starling, and I represent the defendant Level Smart Foundation Repair, Inc.
And good afternoon, Judge Meachum, Brian Buster for Natasha Harper Madison and Thomas Madison.
Thank you. There is a motion for summary judgment and a motion to strike. And so who are the movants on those motions?
Yes, Your Honor. The movement is the defendant Level Smart.
And I see there's other defendants, but none of them are, either they're not here or they don't wish to enter an appearance this afternoon, correct?
That appears to be correct. I think one of the defendants was actually filed a motion to dismiss. It was granted.
All right.
That's correct, Your Honor.
Okay, thanks. Go ahead. Proceed on your motion, Mr. Starling.
Thank you, Your Honor. So this case has been on file since February 11th, 2022. So we're talking a period of almost 3.5 years. During that period, Your Honor, the plaintiffs have performed zero discovery. And by zero, I mean they haven't even served their initial disclosures in this case, despite the fact that they were due on April 13th, 2022, more than 3 years ago. We filed back in April, we filed a motion for summary judgment. The response to that was due on June 2nd, 2025. And again, this was just a no evidence motion for summary judgment on the claims asserted against Level Smart. They had asserted a DTPA claim, a breach of contract claim, and a breach of warranty claim. As we allude to in our motion, Your Honor, the allegations against our client were very vague. In fact, I actually originally filed a motion to dismiss, but unfortunately, Mr. Buster had a conflict on the date of the hearing, and it ended up extending us past the deadline for granting motions to dismiss. So this case has languished for the last 3.5 years on the court's docket. There is no trial setting at this point. Discovery period closed several years ago. On June 2nd, the plaintiffs filed a response that for the very first time attached a purported expert report from an individual named Charles Fowler. Important to note, as we point out in our reply, Your Honor, that was an unauthenticated report, so it's hearsay. And the other problem with that is that report has apparently been around since July of 2020 and was being produced the first time 7 days before the hearing. Important to note, as part of our motion to strike, Your Honor, we moved to exclude the evidence and strike him as an expert under 193.6 for failure to timely make, amend, or supplement discovery. He has never been, the expert designation deadline was September of 22, so we're almost 3 years ago, and Mr. Fowler was never designated as an expert. And so we've moved to strike on those grounds. It is not timely, and all the case law on this is pretty clear, and we've cited that in our reply. In fact, there's a case almost directly on point that we cite in our reply out of the Austin Court of Appeals. That is Cunningham v. Columbia St. David's Healthcare System, 185 Southwest 3D7. That basically said a non-designated expert's affidavit cannot be considered as summary judgment evidence unless a party shows good cause or lack of unfair surprise or prejudice. There's been no motion or response to our motion to strike alleging any type of good cause or lack of unfair surprise, and obviously it's been produced 7 days before the hearing, so it is deemed untimely. And even, Your Honor, if you read the report doesn't actually specifically mention my client. There have been several foundation companies. In fact, there's another foundation company that's a party to this lawsuit as a defendant, LoJack, if I recall. None of Mr. Fowler's report actually implicates my client. And we point that out in our reply. So we have moved for, again, a summary judgment. We do not think that the court should consider the untimely disclosed evidence for several reasons, unauthenticated, and it's not timely under 193.6. And also, it just doesn't support his claim. And so we have moved for summary judgment. We've also asked, Your Honor, and I typically don't do this, but we've asked for fees under Rule 13 and Chapter 9 of the Civil Practice and Remedies Code. We do feel that this is a frivolous lawsuit, so we included an affidavit with our motion asking for $3,487.50 in fees against the plaintiffs. And I think it's pretty clear from their petition that, you know, the vague assertions in their petition that there really is no claim being asserted against our client here. So we'd respectfully request the award of attorney's fees in addition to the summary judgment motion.
Your Honor, may I respond?
You may.
So first of all, the report does raise a summary judgment fact. Okay. There's also included in our exhibit is the actual warranty that was with the previous homeowner, who's a defendant in the lawsuit, which transferred to us. Now, the assertion that it wasn't produced until the day the response was filed is, I guess, there's a little more to it than that. It was originally produced by Richard Bond, the other defendant in this case, 3.5 years ago when they responded to initial disclosures. I merely Bates labeled it for us and supplemented so that there was no, claim that it wasn't being produced by us as well. So, but it was originally produced by Richard Bond, the other defendant in the case, and Bates stamped by him 3.5 years ago. So it has been in the possession of other people. Now, we are not relying on it as an expert report. We have not called him as an expert. We are just saying that it was prepared. It's been in the hands of the other defendant. It was produced by another defendant, even though it is against his party interest. And as a result, it is competent summary judgment evidence for the purposes of responding to this motion. I agree that this case has been around for a while. There were some issues with the clients and their personal lives. And as a result, it kind of sat there. But we are ready to move forward against all defendants should the court deny their no evidence motion for summary judgment. In short, they asked for some evidence. We gave them some.
So what is left? There are, I think there are some other defendants who are getting out, or attorneys who have withdrawn and other attorneys who've gotten in. What's this case is the Madisons?
Yes, Your
And
Honor.
who are the defendants? Is it just Level Smart, or are there other defendants that are left too?
No, Your Honor. The remaining defendants are Investors Choice, Real Estate LLC, Richard Bond, Mimi Bond, 91.8 out. Francisco Alvarado DBA LoJack Foundation is still in it, and so is Level Smart as of today.
And do you have this set? Have you set it on the docket for a jury trial or anything?
No, we have not, but we would be happy to set it, as soon as possible within 45 days. I was in Judge Mozzie's court, and she was also earlier today, and she was also suggesting that parties set things for trial as soon as possible. So we will certainly endeavor to do that. And with regard to, I also want to say that the evidence itself, you can see when the warranty was made. The report was issued after the warranty was made, which indicates that that report is dealing with foundation review that happened after the warranty was given, aka after Level Smart did their work. So I wanted the court to point to that as far as there being a scintilla of evidence as to both our breach of warranty claim, our breach of contract claim, and our DTPA claim.
And I want
Your Honor,
to
ma'am.
hold on. I want to make sure I'm seeing everything that is relevant to this particular hearing. I have a Level Smart no evidence motion. I have the plaintiff's response, and then I have the defendant's motion to strike the plaintiff's summary judgment evidence. Those are the three things that I should have for purposes of this hearing, correct?
That's correct.
All right, and you get the last word, Mr. Starling, because it's your motion.
Sure, Your Honor. The fact that, okay, first of all, I don't believe we have a copy of that report, number one. Number two, we didn't produce it. It remains unauthenticated. He's got no sponsoring witness that has, with personal knowledge, that has vouched for the authenticity of the report. It's not being used against the party who produced it. So it remains an unauthenticated document, remains hearsay, number one. Number two, even if this was not his expert, and it's an unretained expert, he still had a duty under 195 to designate Mr. Fowler as an unretained expert if he's going to rely on Mr. Fowler's opinions. And that's the problem with the argument that was produced by some other defendant, which I can't confirm, but was produced by some other defendant several years ago, is he's never designated Mr. Fowler as an unretained expert in this case. So that argument just doesn't, in my opinion, hold water because of the failure to designate and the fact that it remains an unauthenticated document.
And Mr. Buster's proposed order here would be pretty simple. It would just be denied. But have you, Mr. Starling, presented me with some proposed orders? Where can I find
I have an order on the motion for summary judgment. Yes, Your Honor. Hold on just a second. Let me pull
You don't
that
have to
up.
find it right now, but I need any proposed order that you want the court to consider. This goes for you too, Mr. Buster. If you would both send them to my 201.submission@traviscountytx.gov.
And Your Honor, I did send that at about 1:39 today. In order denying. I noticed a typo in it after I sent it off, so I'm probably gonna update it and resend it.
Great. If you could both send them proposed orders to that, because I'm going to take this under advisement and I will let you know.
I'm sorry, Your Honor. Could you repeat that one more time? 201.submission?
At traviscountytx.gov.
And Brandon, you were copied on it.
Okay.
So if you want to respond to mine with the proposed order.
I will. Thank you.
All right. Thank you, gentlemen. We'll go off the record and you're excused.
Thank you.
Thank you.
And so that takes us to the Canada case. Give me a quick 3-minute break and then I'll come back and begin Canada. Though I will say, Miss Canada, if you are seeking a default judgment, if you're seeking a default judgment against a party who has answered, I'm going to reset it. So I'm going to also check the file here and I'm going to see if they have in fact answered. But you can check the file while I'm doing that too. But we'll deal with it in a few minutes. Thank you. So let's get everybody back in Canada versus a large list of people. There's quite a few. Well, so we're not on the record yet. But Miss Canada, this case is very confusing to me. I'm going to be honest with y'all. I'm looking at it right now and it looks like there's a lot of things going on. But as for today, Miss Canada, it looks like you've set a motion for default judgment against Mr. Clark. Is that right?
Yes, ma'am.
And Mr. Clark did answer. He filed an answer. I mean, we have to afford every courtesy to self-represented litigants, and we have to sometimes read things as answers, even if they don't have the magic words. And I do see that he has filed a letter that probably keeps this from being a default judgment. That is my interpretation of the law. He has put something into the record with the clerk that shows he does not believe he should have a default judgment granted against him. And while it is not the legal language that I think a lawyer would advise him to write, I think taking and affording every courtesy to a pro se defendant, a pro se litigant, I need to treat it as an answer. And so motion for default would be denied. You would need to set something else going forward. But since I have you here, and I have a couple of lawyers here, it looks like, representing various parties, I just wanted to take a minute and see if we could figure out what's going on here, because the file is a bit confusing to me and a bit confounding, and I want to try and understand what we need to do to get this case on some sort of track that is helpful. So what do you think you're suing for, Miss Canada?
Okay. So me and my sister are pro se. Perry Clark did file a letter. It's not considered an answer. It doesn't have his general denials or defenses. It doesn't have a certificate of service. He did not serve it upon us. It does not have his phone number, email, or proper address for me to respond to him. This case is solely about my grandmother's homes, my maternal grandmother's homes. She had 2 homes in her life estate when she died in 2015. Perry Clark is not an heir to those homes. He decided that he was going to file some affidavits of heirship and just sell one of them and put him as a co-owner on the other. So I filed my lawsuit, and I filed my lawsuit against Perry, and he was properly served April 30th. He did submit a handwritten letter on May 21st, but it does not meet the requirements of Rule 92. So my mother, Teresa Canada, preceded my grandmother in death in 2006. My grandmother died in 2015. Ashley and I are the heirs to those. He is not an heir. He never filed probate. He just used false affidavits to sell one of her homes out of her estate. There is a property at 1170 Paquito currently that he put his name as co-owner currently to that property. The property that I grew up in, that you will see on my sister's birth certificate as a home that we lived in when we were born at, we grew up in 2015 when she died. All of my family lived in it, from my brother to my aunt to everyone around us. That is 7010 Carwill. That property was sold to Ibiza Homes 3. They took the property. If you can look at it in the CAD and in everything. And there's a lot of different affidavits. He filed some kind of Les Pendes on it, all kind of things. So there is proof that there was some kind of issue with the property and it should not have been sold. My main focus is to get our properties back. We grew up in these homes. They are not to be passed around, especially to people who did not know my grandmother at all. So.
All right. So let me ask a couple questions. Who are these other lawyers? Who do y'all represent? Where are you in this?
Good afternoon, Your Honor. My name is Andrew Oliver. I e-filed over the weekend. I got brought in super late on Friday afternoon and have e-filed or submitted for e-filing a notice of appearance for co-counsel. I represent Ibiza Homes 3 LLC.
I don't even, oh, no, that's right. I see that answer. Yep. Oh no, that's Mr. Sessome's answer. I don't think I've seen yours yet. I don't think it's even made it into the file yet.
Yeah, and it's just yes. And like I said, it was submitted for e-filing over the weekend. I got brought in and found out about this hearing Friday evening after business hours, and so
all right.
I'm here, but my appearance has not been accepted by the district clerk yet.
Okay, and then Mr. Sessomes, who do you represent?
Yes, Your Honor. So Mr. Oliver is actually co-counsel. He's a partial representative of Ibiza Home 3 on just a number of claims. I do actually represent every single other defendant, including Ibiza, except for Perry Clark. Essentially what you have here, as you heard Miss Canada's exact words, she's upset because her grandmother had a life estate and the rightful owner of that property sold the property to Ibiza Homes, and Miss Canada went and sued every single person with the same mailing address.
Your Honor, I'd like to clarify for the record. I was served earlier this morning a notice of substitution of counsel, and that filing was signed by Mr. Gammon and Mr. Sessman, and it states Mr. Sessman has been fully released of all obligations, and Mr. Gammon is now counsel of the record for the remaining defendants, everyone except for Perry Clark. So accordingly, I don't think Mr. Sessman is supposed to be authorized to speak here.
Well, I haven't seen that yet. So that might be true, but I haven't seen it yet. So I don't, again, our files, sometimes they don't make it quite all the way into the clerk's file. That doesn't make it quite to me. You may be right, Ms. Canada. This case, it's a no for me on the default judgment. That's all I'm deciding here today. It's a no for me on the default judgment against Mr. Clark. I recognize that we have another person sort of filing something without actually putting any of their contact information in the file, which is problematic for a lot of reasons. But nevertheless, I have to treat it as we afford a lot of courtesies to self-represented litigants, including when it comes to an answer. And that's really it. That's where it ends. But when it comes to an answer, that's the charge of the court. So the default judgment with regard to him is denied. Hearing this case, it almost sounds like you need to set this for final trial, Miss Canada. Like you almost need to go 45 days out and try to get it set. It's almost like a trespass to try title, removal of lis pendens. But the thing that's confusing to me is, of course, if there has been a probate matter in this, or if there has been any sort of probate issue which would determine the case. And that may be what Mr. Sessoms has, but it's a no in terms of any summary judgment.
There's been no probate.
I'm asking. We see these from time to time, cases with family and property fights and things like that. But today it's a no for me on a default judgment. I'm just trying to help you. I'm trying to kickstart this in a helpful way, because it's a very messy case. I can see that it's got a lot of mess to it. So I'm trying to, without giving you any legal advice, explain to you why I'm not granting your default judgment, and explain to you process-wise what I think would be the best way forward. But I can't give you legal advice. This is going to be very complicated for you, Miss Canada, without a lawyer, because there's a lot of very difficult legal terms you're throwing around, and it gets pretty complicated. If you watch me this whole time, when it comes to real property, the law it's a more difficult process. So if you can't find a lawyer, you can't procure a lawyer, I understand that, but it's a no for me on the default judgment, and everybody is excused. Thank you.
Your Honor.
Have a nice afternoon.
One thing, Your Honor, due to the nature of the way that her motion's written and her waiver of that motion against all the other defendants was before the record, can we get a ruling on the default against all of the defendants in this?
I'm sorry. I thought it was just to Mr. Clark.
No, her
No,
motion
it is. It's strictly for Mr. Clark. I put in a proposed default judgment for submission strictly for Mr. Clark, but I was served that you are no longer counsel, so I don't understand.
Well, I definitely see an answer in file for all of the Ibiza. Oh, let's see.
Yeah, Judge, if you look at her pleading at her motion for default as well as her second motion for default, she names everybody.
Right. Oh, and it's denied as to everyone. The motion for default judgment's denied as to everyone, because there's been answers on file. So that's all we can do today is just say no and hope that this case builds some structure around it, because it does need like a setting on some actual contested legal issues that the court needs to start getting to. But it's a no on the default judgment as to all the defendants. Thank you. You're excused.
Thank you, Your Honor.
That takes us to the last case.
Yes, ma'am.
Okay.
Yes, Your Honor. Partially opposed.
I'll say not really very opposed, Your Honor. Just couldn't agree.
That was
the point.
That was my sense, but
Well, that puts me in a very difficult spot. Because Ms. Collins knows this. All the motions for continuance in the top 6 counties have to be logged by every district court judge. And so when you bring me a motion for continuance because of the legislature's tracking of judges, we're inclined to deny them, because we have to make reports about them and log who we granted them for. Now, it puts me in a very difficult position. So if you just agree to reset, I don't have to deal with it. But if I have to do this, I have to fill out a report about it. So I don't think they quite understand the amount of hassle and work this is for every trial judge in the top 6 counties. And I know lawyers don't understand that. So that's why I am informing you of that. That all of the judges in these top 6 counties by population have to log every single one of these. And when we grant them or deny them, we have to say who we granted them for or who we didn't. I mean, it's amazing the amount of work that this requires.
Let me ask you this, Your Honor. I think I can agree, and maybe if I can satisfy or satiate my client if we just look at potential dates and just have a discussion that's not too lengthy of a continuance. I don't want you to jump through a bunch of hurdles for something that's more of a technicality on my end. So
I can do a few things. I can give you a setting, and since y'all are coming in basically a collaborative posture, I can also do backup settings if that's something that works as well. And that way, if you don't kind of get reached first time around, you can get reached the second time around. Or if you're aiming for that just ambitious date, but the ambitious date just can't quite work, then maybe the secondary date works better. So when are you set for trial now?
August 18th, Your Honor.
And it's the defendant who's wanting to push it?
Yes, Your Honor. I mean, just brief background. I know it's styled, or it looks like it's a motor vehicle accident case, but it's not a garden variety motor vehicle accident case. I represent Lupe Tortilla restaurants and one of their partners, and then I represent the individual defendants that work for them. And Mr. Cotton's client was in a head-on collision with Ms. Collins' client on North Capitol Texas Highway. Her client was going down the wrong way on North Texas Capitol Highway and ran into Mr. Cotton's client, Mr. Williams. Very serious injuries. We've got thousands and thousands of pages of medical records. The suit was initially filed by Mr. Williams against Ms. Collins' client, who perished, by the way, in the accident, Your Honor. And then in some written discovery, obviously, it came to light that my folks catered a wedding rehearsal, and then my folks were brought in the first amended petition that was filed in September. When I say my folks, Lupe Tortilla was brought in an RDM initially in September. And in that window before we actually answered the first DCO and the first trial date, trial date was entered and a DCO was entered without us being in the case yet. And then my folks that were named in the first amended petition appeared. And then we disclosed the names of some people that were working at the rehearsal. And then so all those individually named defendants were added in the second amended petition in November. And so those individual named defendants, a couple of them appeared in December. Mr. Simon Labia was actually added, and I have a typo on my motion. It obviously was February 2025. So anyway, there was a lawsuit pending before I was in the case, and it was set for trial, and an amended or agreed DCO was entered. And I'm not saying it's a sole basis for continuance, and we've, I laid out in here, Your Honor, we've taken 7 depositions. We've got a couple more on tap, but the main issue, well, first of all, yeah, I come in late and, I'm trying to play catch up, but Mr. Cotton disclosed that his client's got a surgery scheduled July 18th, which is 10 days after, July 8th, which is 10 days from our discovery cutoff. We've done some Band-Aid Rule 11s on experts, but there's more work to be done. It's not your garden variety motor vehicle accident. We're exchanging about 6,000 pages in comp records as we speak. And we've got a few other depositions we're scheduling for late June or early July now. So that's a thumbnail sketch of what's going on.
And so when do you think you can realistically, if you were asking for the continuance, you were wanting it until when?
Yeah, I said about 180 days. 6 months, which would, by my calculation, it was going to put us into February or March. February would be the 6-month point. I don't know when Mr. Cotton was saying, how far out.
And Miss Collins, you're joining in on the continuance. Is that where you are? Or are you agnostic?
Well, I'm unopposed here, Your Honor. I agree with what Mr. Floyd has represented to the court today. There's thousands and thousands of pages of documents we still need to go through, especially with a new surgery coming up. And then, I know Mr. Floyd indicated, late June, early July for these additional depositions, but in looking at my calendar, it probably won't be until closer to mid to late July or early August, honestly. So.
And then, Mr. Cotton, you have some issues with your schedules, it sounds like, with your client as well, on top of that.
That's correct, Your Honor. And so ultimately, I think pushing this to, I was even thinking early summer of 26 reasonably for what's still left to get taken care of.
In all candor, Your Honor, I think that's probably more realistic. But when we come in and ask for a continuance, he said not a lengthy one. I'm trying to do the best we can and be as efficient as we can. But I don't disagree with the representation that we're probably looking to next summer.
Well, I appreciate all that. Like I said, like y'all are making me, for something that you're basically in agreement to, take a hit with the legislature who's going to make me look like I'm not doing my job. So I
Yeah.
could use your help telling the legislature this is bad micromanagement of judges because they're not able to do the things that they need to do to help lawyers help their clients make reasonable calendaring decisions. I mean, it really does hamstring us. So just keep that in mind when you're appearing in one of these major 6 counties and why judges might be being more difficult on reasonable requests for continuance. I think they passed this bill because they think some criminal judges aren't doing their job as much as they want to, and they just brought the civil judges along for the ride. And they don't even really understand that it actually is probably incentivizing judges for the wrong thing, which is they spent all this time on tort reform, and now judges are supposed to not actually close cases. I mean, we're only supposed to close cases at final trial. They don't even give us credit for closing cases on anything else. And they're making us not continue cases that should reasonably be continued. So I say all that because I really don't want to take a hit for a continuance for a case that y'all are basically agreed to. I can do a setting in February, and then we could do like a June setting too. We could take a February setting if we all go quickly, and then we do a June setting if you need the backup. I mean, I'm okay to do that, but I don't really want to do. I mean, he's saying February now, Mr. Cotton, and you're the one saying June. So
Yeah.
are you opposed or are you in favor?
Let me rephrase, Your Honor. My motion said at least 180 days, which was at least 6 months. I would modify it and say I don't disagree with Mr. Cotton that I think it's more realistic that we're going to need until the summer. So.
Okay. Well, I'm fine with that, but I would rather not do a continuance, giving this case a year of a continuance and have that hurt me later on when you're all basically in an agreed posture. I mean, help me, help you. So if you want to reset it, I have somebody from court administration watching right this minute. And if you want me to tell court administration to reset your case and you're all in an agreed reset posture, then I am happy to do an agreed reset. And then I'm also happy to take an agreed scheduling order based on that agreed reset for you to send it to my submission folder and for us to get that signed and filed. That's what I will do if that is something that works for all of you.
That works for the movement, Your Honor. I don't have that agreed DCO. We haven't circulated that yet.
I know. Well, I'm just saying when you get it done, right?
Right.
But let me look at what the jury docket in Travis County looks like for 2026. We already have it up. And let's go ahead and get you scheduled since I know I have somebody who can do that who is watching. Hold on. Maybe you don't need the backup setting. If you're setting it this early, you don't need it really. I think you're going to have, you will have a good line number. You will be reached. If you keep this date, you will be reached. I can't 100% guarantee it, but a year in advance, I feel confident you're looking pretty good. 2026 docket schedule. Jury docket is June 1st. Jury docket is June 22nd.
The 22nd works for me, Your Honor.
Same here.
I'm good with that as well, Your Honor. Thank you.
Okay, then I'm going to take this as an agreed reset and have the court administration set you June 22nd of 2026. How it works, since some of y'all are out of town, what happens is what we do now in Travis County is I actually call the docket 7 to 10 days before by Zoom. And so you'll get a little notice from me to show up for your Zoom hearing, and I'll set out the docket and tell you your judge at that point. You know, in the meantime, y'all will be setting all of your things on the central docket. It works very much similarly to the presiding docket in San Antonio, but we do it a little more in advance, not same day. We try to give you your schedule maybe the week before. So, but that's how a jury trial will work. And any questions for me before I let you go?
No, Your Honor. Appreciate the background information. Very helpful to know.
All right.
Thank you. Yeah, and I apologize for I didn't realize that was a thing for the legislature.
I mean, I will say to you, it's causing a lot of, like, you know, judges, it's a lot of work. Every bit these counties, Harris, Dallas, Travis, Bear, Collin, and Tarrant, that I think are just along for the ride under duress. They weren't mad at them, but they couldn't have the rest of us do it without them doing it too. We're all just having to keep our numbers on continuance motions, which is really wild and bizarre, but that's one of the latest things we're having to do as a result of all this judicial scrutiny. So, oh well, thank you. I appreciate it.
I appreciate you telling me that, Judge. I mean, I'll pass that up internally as well, that, hey, this is a thing we need to be aware of. So I do appreciate you letting us know.
Agreed.
Okay.
Thank you, Your Honor.
Thank you.
Be excused. Thank you.
Y'all are excused.